Sorry guys, continuing on with the rule of four. 4 of the 9 justices have to agree to hear or review a case. Most of the time the Supreme Court likes to let prior decisions of the court or prior precedents established stand. They try not to hear issues that they feel that they've already ruled and decided on, and they won't, once they hear a case, they won't pick the case up again unless they believe there's a new angle or a new issue that's not yet been addressed. So once the Supreme Court, at least 4 of the justices, decide to hear a case, they issue a writ of certiorari where they direct the lower courts or the last appellate court to provide all records regarding a case when it has been petitioned for review. And then the court is the justices are provided with case briefs. These are written arguments that are provided to the Supreme Court prior to oral arguments. They cite legal arguments, legal precedents, previous court decisions, anything that will help their side. Interest groups provide amicus curiae briefs. These are friends of the court. It's information when the interest groups have a vested interest in the way the case is going to be decided, but they're not an actual party to the case, so they provide information, additional perspective, try to persuade the justices to sort of see their way of thinking. It doesn't always work, but they try. And then oral arguments, each side has exactly 30 minutes. When there's a box in the court that has a green light that turns on when it's that attorney's chance to present their oral arguments. They can and are frequently interrupted by the justices in their presentation when they ask them questions. It's sort of the way that the justices talk to one another because they've already researched and read and have been briefed by their legal clerks about each of these cases. And in some instances, they've already sort of decided what the law says and how they're going to rule on the case, but they use questioning the attorney as a way to sort of talk to one another and throw their own ideas out. Once the 30 minutes is up, a red light comes on in this wooden box, and the second that red light comes on, the attorney presenting their oral arguments is finished completely. So it's not one of those things where you can just keep talking if you're not finished. You have a Solicitor General as part of the United States Justice Department that argues on behalf of the United States for the Supreme Court when the U.S. is a plaintiff in a case. So after the court hears oral arguments, they have conferences where they go to the Chief Justice's office on Wednesday and Friday afternoons, and it's only the 9 justices. They do not allow law clerks or administrative assistants or anyone else in. It's just the 9 justices. They take a preliminary vote on how they're going to decide the case, and then the most senior justice who's in the majority opinion is usually assigned writing the majority opinion unless it's the Chief Justice, and the Chief Justice doesn't have to be senior. He just gets to do what he wants to do. They outline their legal reasons in their opinions as to why they've decided the case. You also have dissenting opinions when these are the justices who disagree. You can have a 5-4 case where 5 rule in one way, and then you could have 4 different dissenting opinions. Most of the time you don't actually have 4 different dissenting opinions, but you could. So the justices who disagree with the majority will outline their legal reasons as to why they disagree. And then you can have a concurring opinion, which does also happen frequently, where a justice votes with the majority to decide a case, but they do it for completely different reasons than maybe the rest of the majority did. And that's all we're going to do for today.